Our afternoon session now. Everyone can find their seats. That means Michael, Tim, and Corey. Please, yes. Okay, so let's begin. Is this on or on? Okay, let's begin. So, one of the very nice things about this gathering today is that we get to welcome old friends back to the department, and we've met previous students, and now we get to meet a previous faculty member. Wayne Martin received his PhD from the University of California, Berkeley in, when was it, 1993. And he thereafter joined the UCSD department and rose through the ranks from assistant to associate to full professor in 2005. And in 2005, he made the momentous, and from his point of view, good, from our point of view, bad decision. It was time to decide, and he debarked to the UK, to the University of Essex, where he now serves as head of the department, a very lively and successful department there. Wayne is the author of two books, Idealism and Objectivity, Understanding Fichte's Project, Jena Project, and Theories of Judgment, Psychology, Logic, and Phenomenology. He's a very productive researcher in the areas of the history of philosophy, phenomenology, the metaphysics of ethics, maybe, a way of thinking about what he does. He's at work on a new, very large and ambitious book project, Self-Consciousness, an Alternate History, that we heard parts of yesterday. Today, though, he's going to be talking about another aspect of his work. He has a very, very well-funded project called the Essex Autonomy Project, and this is a very, very exciting endeavor that brings together philosophical theorizing, the history of philosophy, with practical real-world issues of autonomy in healthcare, in criminal justice, all sorts of areas where it really matters what kind of decisions people make, whether they make good decisions or bad decisions. And it affects professionals who have to engage with those people and help them make better decisions. And so Wayne's project, I think, is in part involved in helping to make that whole system of decision-making at the social level work better, or at least that we can understand how it works. And so I think maybe he's going to be talking a little bit about some of the aspects of that today, and the talk is Time to Decide, an Exercise in Applied Phenomenology. Wayne Martin.
Okay, thank you. I'm going to resist the temptation to reminisce because I want you guys to work for me. So I'm going to talk a little bit about some problems that we're working on. It's mostly problems, very few solutions as part of this Essex Autonomy Project. I'm really pleased to be invited back. It's great to see old friends and to revive old quarrels and so on. So thank you for inviting me and including me today. So here's my plan. Don, you're going to have to keep me to time because I have a lot to say, and you're just going to have to cut me off at a certain point. Okay, you try. Yeah, just wave at me. Yeah. So I'm going to talk a little bit about the Essex Autonomy Project. Don asked me to speak about that, and I do think of this as carrying on UCSD philosophy by other means and in other places. As you'll see, a lot of the things I learned here at UCSD are coming into play in this work. So I'll talk a little bit about that. Then I'm going to talk a bit about the legal landscape in England and Wales right now. It's a rather specialized legal landscape, although I think it reflects an underlying structure that will be familiar to everybody who took Henry's seminars. And then I want to talk, there's some work I've been doing with Ryan Hickerson. Many of you will know him, a PhD from our department, sends his regrets today. We've been doing some work on different methods for testing for mental competence, and so I want to run through 3 possible ways of thinking about that. And then if we have time at the end, I have a couple of stories to tell, contested cases where we apply some of the results. Okay, so the Essex Autonomy Project is an interdisciplinary research project. It's not a liberation movement for Essex. We're not seceding from the European Union. If you know about the reputation of Essex in the UK, you know you have to explain that. It's funded by the Arts and Humanities Research Council. There's also a clinical project that's funded by the Wellcome Trust that takes place at the Maudsley. Increasingly, though, we're also involved in public sector issues, and we're working with the Ministry of Justice. The Office of the Public Guardian is the person in Britain, civil servant in Britain who has the responsibility for protection of vulnerable persons. The Institute of Psychiatry is an NHS facility, and the Department of Health has had obligations for implementing this new legislation. So we are now the NASCAR of philosophy here. We wear these vests everywhere we go. So the research is really organized around this idea of deciding for oneself or making up one's own mind. Quote here I have from one of the research subjects: "I made the decision on my own in the end." So one way to think about what we're doing is we're trying to figure out the truth conditions for that proposition. And we've organized that around this idea of autonomous judgment. It's kind of the Fichte legacy working through here, or the post-Kantian legacy, to think about what autonomy in judgment is. Some people think all judgment is autonomous. I think that was Rousseau's view, and I'm partial to that, but we don't take a stand on that right now. It wouldn't be judgment if it weren't autonomous. But we're particularly working on cases where it's contested, where there's a quarrel in the courts, in the hospital, in the prisons, in the police services. So what we call contested autonomy, or what technically comes out as this issue of contested competence or contested capacity. So I want to talk about one little slice of this big work today with an example about the capacity to consent to or refuse medical treatment. It's a big issue in medical practice. People sign consent forms all the time. The issue sort of generalized from there to a lot of other cases. For instance, there's a big issue right now in Britain about the mental capacity to enter a plea in a criminal proceedings. Under what conditions? What kind of mentality do you have to have in order to be competent to enter a plea? But I'm going to, for today, focus on this particular case that has been at the center of our concerns. So let me talk a little bit about the legal context here. I think it's actually, it's really very interesting. One question is, to what extent is it parochial? This is maybe something distinctive about English and Welsh law. I'm not going to try to address that question. Part of our project does have take up issues of comparative law and comparative international law in different jurisdictions, and there's a lot interesting to say there. But I'm just going to focus on the English case for now. So start with we got these two bodies of law as of 2005. By coincidence, exactly when I arrived in the UK, we've got these two bodies of law that apply in these cases where you're trying to decide whether somebody has the capacity to decide. So one of them is the Mental Health Act. Mental Health Act is 1983, but it's the latest incarnation in a very long-standing legal tradition, and you find some version of it in every jurisdiction. It's rooted in Victorian legislation governing asylums, lunatics, and madhouses. Those are three bits of progressive legislation in the Victorian era. But its basic powers date back to 1714, to the Vagrancy Act, which gave the state the power to detain those, I love this phrase, who are furiously mad and dangerous. So that's been a kind of power of the state. It's, of course, been subject to a lot of abuses and a lot of reforms, and you get this progressive series of reforms of that power. So it establishes nowadays the power for involuntary treatment of individuals suffering from a mental disorder. In 1714, that was meaning locking people up, completely deriving them of their civil rights. Nowadays, of course, it's mainly medications are involved. So here, I won't read all this, but here's the crucial bit of the MHA. This will be familiar. There's an exactly analogous bit of California law we're studying at the moment. So this is what it is to be sectioned under the MHA for admission for involuntary treatment. And the crucial thing there is C. You can see it's been amended, and amended B no longer exists. But the crucial thing there, you can be admitted for involuntary treatment if it's necessary for the health or safety of the patient or the protection of other persons. So if you're a danger to yourself or to others, that's, I think, the California formulation, and you have a mental disorder, then you can be involuntarily treated. Okay, that's a very familiar legal instrument and a long-standing power of the state. There are various kinds of checks and so on, safeguards that have been introduced over the centuries. The news story here is a story about the Mental Capacity Act. It was passed in 2005. It came into effect in 2007. And it's only just now in the last 12 months or so beginning to be adjudicated. You're getting the first set of cases. And there's some predictable contradictions that are coming out in the rulings. So this is not a passage from the Act, but the Act was really codifying some case law decisions in the 90s. This is a quote I really like. If you've got case law powers, you can make these grand pronouncements. This is a judge ruling in a family court case. A mentally competent patient has an absolute right to refuse or consent to medical treatment for any reason, rational or irrational, or for no reason at all, even where that decision may lead to his or her own death. You could spend a long time analyzing that claim. I mean, it's interesting. It's an absolute right. There are very, very few absolute rights. David will tell me what's left. I mean, it used to be the example of an absolute right was the right not to be tortured, although even that is nowadays up for dispute. But here's an absolute right in UK law. The absolute right to refuse treatment. If you don't want to have it, you don't even have to have a reason not to want it. You can just refuse it. But in a weird way, it's conditional at the same time. That sounds like a contradiction. How could it be both absolute and conditional? I think it's not really a contradiction. It's an absolute right. If you have it, you don't have to weigh it against a state interest or the interests of others. You can just refuse treatment. But you only have it, that's the first part of this sentence, if you are mentally competent. So that's the conditional part. Absolute right, but with this buy-in clause. So deciding whether you're mentally competent turns out to be really, really important in these cases. If you're competent, you have this absolute right to refuse treatment. If you're found not to have this capacity to make your own decisions, then all of a sudden your rights disappear and a bunch of best interest duties kick in on the part of the state. So the Mental Capacity Act sort of takes up these judicial rulings from the 90s and tries to codify them. Again, here's the one crucial passage from the statute, which defines, they actually don't define the ability, but the inability to make decisions. So a person is unable to make decisions if he's unable to understand the information relevant to the decision, to retain that information, to use or weigh that information as part of the process of making the decision, or to communicate his decision, whether by talking or some other means. So that's the definition. And it's a beautiful legal definition because it leaves all kind of scope for quarreling and interpretation and implementation in case law. So, okay, those are the two legal regimes. What I want to do is just contrast. There are two, it seems to me, two different views of the patient here that are operating under these two laws. Under the Mental Health Act, it's really you're taking a health and safety perspective. It goes back to those vagrancy powers from the 18th century. The key aim there is to keep people safe, to keep the patient safe, keep other people safe. The Mental Capacity Act is really taking a rights and agency perspective, and it's really rooted in European human rights legislation and so on. So I think those are two different perspectives. And there are different sorts of questions. If you're a psychiatrist working with somebody, you have to ask different sort of questions depending on which legal regime you're operating under. Under the Mental Health Act, you have to ask, will the patient be a danger in one way or another? You're trying to make a prediction about the future of a complicated organism in various kinds of circumstances. And when psychiatrists get that wrong, they are subjected to enormous public scrutiny and retributions often. Under the Mental Capacity Act, you're asking, it seems to me, a very different kind of question. You're asking, is the patient capable of deciding? That's a different kind of question altogether. What's the status of their choice, as I put it? So in the one case, you're called upon to make a prediction about the future. In the other case, to determine the status of a patient's choices. And they operate with different values. The value for the Mental Health Act is overall public safety. But the value that's at work in the Mental Capacity Act is this value of citizens to be autonomously self-determining. So here's a little bit from Lord Falconer, the Lord Chancellor. How often does the Lord Chancellor get quoted in a philosophy talk at UCSD? So this is the preface to the Code of Practice for the MCA. And you can see there the value expressed very explicitly there. It will empower people to make decisions for themselves. And then it goes on to protect people who are vulnerable and don't have that capacity. All right. So I told Henry's here, oh, we have to have a bit of Kant, right? And in fact, when we were working on this, we straight away were very much thinking in Kantian terms, right? Because you go back to those two perspectives on the patient, those kind of look familiar, don't they? One of them is essentially at root a theoretical perspective in Kant's terms. You treat